You're starting with GK? Yes?
See which is which?
Doesn't matter to me. Okay, Mr. McMaster.
Your Honor, just want to state the move into evidence what has been marked for identifications as states GK, GL, and GM. These are certified copies of 4 felony convictions for the defendant Brandon B. Bradley.
Okay, response from the defense.
Objections as previously stated.
Okay, the objections have been addressed by the court. They have been overruled based on the court's ruling during bench conference. GK will be State's Exhibit 181. GL will be State's Exhibit 182. And GM will be State's Exhibit 183.
Request permission to publish to the jury.
Yes, you may. Yes, you may.
State rest, Your Honor.
Okay, ladies and gentlemen of the jury, both the state and the defense have now rested their case. There are some matters that we need to address outside your presence, and so we're going to allow you to recess for the rest of the day so we can address those matters. We should expect to go into closing And then I'll give you the jury instructions and to commence deliberations tomorrow. During this recess until tomorrow, you're going to recess until 8:30 in the morning. Have you be back here at 8:30 a.m. Report to the jury assembly room. During this recess, you must continue to abide by the rules governing your service as a juror. Do not discuss this case among yourselves or with anyone else. Avoid reading newspaper headlines, annual articles. Avoid seeing or hearing television, radio, or internet comments about the trial, and do not conduct any independent research. Okay, for the jury, court will be in recess.
All right.
Please be seated. I think the defense was asking for a copy of this case. They gave me that, and they wanted a copy. So if you could make them that copy so they can have that back. They can have the original. You could give me a copy if you like. Okay, are there any motions to be heard on behalf of the defense?
We would renew our previously made motion for corrected verdict judgment of acquittal as to count one, first-degree premeditated murder. The court has had prejudicial evidence on others. We have none.
Yes, you may.
Your Honor, we would renew our previously made motions, judgment for corrected verdict on all counts on the same grounds as previously made.
Okay, response from the state?
Same argument before we submitted plenty of evidence to establish the truth.
Okay, the defendant's motion for judgment of acquittal is overruled. Okay, are we ready to start reviewing the jury instructions?
We're going through them now, Judge.
If the state could give me a copy. Mr. Lanning?
Mr. McMaster on the topic.
Yes?
Matter.
So the ones up, these right here we're working on? Can I start? Is the defense okay if I start?
Give me just a second, Judge, I can run out and do the deliberations on some of them.
Okay. Since I had the clerk read the witness list, do you think I could have the clerk read the jury instruction?
Just saw a case on that, Judge, with the reverse, Judge.
Better take my Wheaties tonight. It's a long packet, this is a big packet of jury instructions. We will be ready. Thank you. See, at least some other judge had that same idea. I can already tell the headings on these aren't bolded, and the headings on the other ones are bolded. So when we get to those, we may have to change that.
While we're going through them, Judge, I have those things.
Okay, we'll go through those.
The instruction I would have to abnormal mental condition. This I typed up at home, so we typed it in the version tomorrow, or do it here. It's going to take us a few minutes.
Okay, if we'll try to do it here, if we could get, do you want, the one you have, I thought the state had the standard instructions on their computer.
Well, the voluntary intoxication one is a standard. We've already passed that on.
Okay,
This one with the abnormal mental condition, I modeled it after that. It's not a standard, but we're going to be asking that be included in the packet.
Okay.
What do you make
I have to copy these before I can read I have to make copies of this and give them to the jury, so I like to get them so that I can have those copies made. I was going to make them,
Because we'll do it then before we...
yeah, if we can. If not, if I get them first thing in the morning, I can have my JA come in and put it where it goes and grab it and do it while you're doing the closing statements. I would have that
We
opportunity.
can do it tonight.
Okay. But we'll talk about where it goes, yeah. Just don't forget that the top thing, all capped and bold. For the titles. I mean, they've got to all be consistent. And then tell me where you want that, so I can save a space for it.
We've got several of them in place, but let's go through the packet that we have, see if there are any objections. I know that there are going to be some corrections on the packet that we have. The previous revision, Mr. Brown and I did.
Are we ready? I mean, I'm going to go through them one at a time.
Stay ready.
Well, I'm about halfway through these, so we didn't get to this point. Yeah, I think we're close.
Okay, the first one is closing argument. I don't include that in the packet, but I always give that instruction. Okay, the second one is instruction to final instructions. I always give that instruction as well. I don't include that in the packet.
You say you do or you don't?
I always give that, and I don't include it in the packet. Okay, the packet starts with, I want them to think I am thanking them without having to read that I'm thanking them. The statement of charge, we start with that. Any objection by the, since these are proposed instructions by the state, I normally ask the defense if they have any objection. Any objection by the defense to the instruction entitled Statement of Charge?
Okay.
Introduction to homicide, that's the next instruction. Any objection by the defense? Justifiable homicide, any objection by the defense?
Judge, we would have to correct the last portion of that, so that the dwelling house, which the defendant was behind the killing, that would be the vehicle. Or facts.
I just want to stop after attempted murder or contempt felony upon the defendant.
Then we would have to continue on to convey the felony. The vehicle, the defendant was behind the killing.
You say vehicle, and then it says was at.
The defendant was in time of
What's the state's response to that?
cases. And it would appear that if we remove the dwelling house and substitute vehicle, what are we talking about? That's the bottom line.
Say that, so complete, if we were,
The last sentence after the comma, the second middle sentence, or to commit a felony in any vehicle in which the defendant was at the time of the felony.
so what are you saying that you agree with that, or you disagree with that?
The standard instruction just says dwelling house, it doesn't refer to a vehicle, but I think that under the facts of our case, it would be appropriate to substitute dwelling house for vehicle under the current law on self-defense.
Okay, I'll take out dwelling house, we'll substitute it for vehicle, and to be grammatically correct, in which the defendant, do we say was in at the time of the killing?
I think just the way it is.
Was
In
at,
which- in which the defendant was at the time of the killing.
okay. I'm okay with that. Do you want to make these changes as we go, or are you going to make them at the end? Or make them tonight?
I'll make them tonight, Judge.
Okay, we can do that as well.
Keep everybody working here.
Okay. Excusable homicide, any objection to that by the defense?
No objection.
Okay. Murder first degree, any objection to that instruction by the defense? Felony murder first degree, any objection to that by the defense?
Just the only thing I can see different from some of the other ones is the names are capitalized in all caps, and some of the other ones they're not. I don't know how consistent the court wants to be on that.
We also asked that the instruction include C or B. Actually, it was during the escape or the escape from the immediate robbery.
Okay, I see Barbara Pill's name capitalized twice, and no other names are capitalized, so if we can uncapitalize that. Now, you're saying you only want 2C? Is that correct, Mr. Moore?
Yes, that's what I'm saying.
Any objection to A and B coming out?
That's not good.
Okay, so it won't be, we take out A, B, and C,
Just the letter C
the letter C, so it'll just have the C
language.
language.
I would suggest we delete for an accomplice. That sentence.
Do you want, does this defense agree?
Right.
And then you'll take out that comma. Or an accomplice comma. So it'll just read, the death occurred as a consequence of and while Brandon Lee Bradley was escaping from the immediate scene of a robbery. It says a robbery. I don't know why A is capitalized like it is.
I wrote it on, handwritten on the other one, which was all caps.
So make that a little a, so it just says robbery.
You want robbery in small also?
Does the defense object to robbery being all caps, or do you want robbery small?
There's no need to capitalize.
So just make it not capitalized. Okay, then we're done with that. We'll move to robbery. I see names all caps. If we can make the names not all caps, just to make it consistent with everything else. Does the defense have any other objections? Any additional objections?
No, okay.
Okay, then fleeing to elude a law enforcement officer, siren and lights activated with high speed or reckless driving. I see down below under operator,
I would suggest removing the section for who is exercising control over or steering the vehicle being towed by a motor.
any objection to that?
No objection.
So it'll be a period before that, and then that'll be deleted. Any other objections by the defense?
No.
Okay. Then we're on resisting an officer with violence. I see names capped, so if you'll just make those not capitalized. It's a shame we started one way because I think they're more the other way. Either all capped or all not capped. I see Brevard County Sheriff's Office deputies too. Take those out too. Making them all caps. Any objections? Other objections by the?
No.
Okay. 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 When there are lesser included crimes or attempts. What does this defense say to this?
Third degree felony murder, I mean, that's the only kind of third degree murder there is that it ought to be, but that's what it is.
Third degree felony murder? Does the state agree?
Fine.
So the word felony has to be added. Anything else with regard to this instruction by the defense?
No.
Okay, on murder, second degree, I see a couple things. Barbara Pill, that has to be not capitalized. Under number 2, there's no period at the end of the sentence. Did you get that, Mr. McMaster?
I did.
Okay, anything else by the defense?
No, that's all right.
On felony murder, third degree, we got to take out 7.6
And the statute,
and the statute number.
we've got Barbara Pill capitalized in the font on Brandon Lee Babbitt. That Bradley is smaller than the rest of them. I'll see if I can fix that. Ramp that needs to be,
Oh, I see that. Oh my gosh, the font is different. Definitely. Okay.
and at the very bottom, I need to delete the instructions about define the crime alleged on attempt.
So the 1 and the 2 are out?
Question is, should we delete the,
Delete B?
I don't think there's any evidence that there was attempted
Well, granted, that the definition includes the intent. So we really don't need to have B in it. It's just attempting at that is one of those statutes that define.
Does the defense agree with taking out B and making C B?
Yeah, that's exactly, we agree.
Okay, so we'll take out B. And then C will become B.
Yes.
And Judge, although the instruction itself says to define the primal edge, which is grand theft is in fact one of the lesser instructions that's given, so we would suggest that we don't repeat it twice.
Okay, does the defense agree we can stop it after it's not necessary for the state to prove the killing was premeditated? With the design to affect death? Stop it after that? Okay. All right, then I'm going to move on to manslaughter. I see where Barbara Pill, that's all capped. So if we'll take that, make that regular.
I can do that, Judge, and there should be, after 2A and 2B, should be a comma or.
Oh, comma, or, and then comma, or.
Three different ways of being able to establish the second element.
Okay.
Judge, then the next thing is you have paragraphs that the killing of a human being is justifiable homicide, and the next one is excusable. They put this in the standard for manslaughter, though manslaughter is always a lesser to first degree, and we've already went through that with them, so I would suggest taking that out because you already have that all in the introduction to homicide. That includes manslaughter.
Any objection by the defense?
I think during a couple of any instructions as part of this,
No, the concern is it's not in any of the other lists. So I've always made this motion on these cases because typically manslaughter, you're not going to do an introduction to homicide. You work first or second. So I think that's why they stick it in here, but to have it in just this one, not in second, not in third, may cause confusion where it's in the overall general instruction that includes manslaughter. Goes back to the introduction to homicide.
Okay, I think to be consistent, it's more consistent if we take it out.
Right, I agree. So,
Okay, then we'll take out, and so it'll go from that the violation is negligence to in order to convict.
right.
Okay. Okay, I see a couple on the second page, Barbara Pill and then the Brevard County Sheriff's Office. Those need to not be capitalized. Anything else in this instruction?
No.
Okay. Okay, I think theft we need to work on. I see capitalize of names, so we'll take those out.
And also parentheses around the danger used or endeavor to obtain or use. Parentheses on the values.
Right, I see that under A, B, C, and D. I see some capitalized in the next, under tangible or intangible.
Yes.
Yeah, we remove the parentheses on those.
Do you need to say, does it need, see how it has the semicolon or colon? It says property means anything of value and includes, can't you just make that all one sentence?
I think we can just do property value. We really don't have an intentional.
You mean you could just say property means anything of value, period? Is this defense okay with that? Yeah, because the rest of it's really not applicable.
no problem with that.
Okay, so we'll stop it after value.
Okay, back on the first page.
Yes?
Um,
Seems like you've got a lot you could take out here.
Well, yeah, that's why I wanted to go back. Realistically, all we've charged is $300 or more. You want to get all that? Then I think we can just have it whether the value of the property taken is $300 or more.
Is the state defense okay with that?
That's fine.
Okay, so you take out all the rest.
Right. And just make that a, take out the $7 And then obtains and uses for just 2 years. And then for obtain or uses, we'll just make that, eliminate B, C, and D, just go with A and make that one sentence.
Okay, any objection by the defense?
Object.
Okay, anything else? I heard you say something else, Mr. Brown.
Court get the, next to the last paragraph on the second page. If you cannot determine the minimum value, you must find that the value is less than $300.
Okay, so it'd be 300 instead of 100.
Yes.
That's what I thought you said, but I wanted to make sure. Any objection by the defense?
No, Your Honor.
Okay, then I'm on fleeing to elude a law enforcement officer, siren and lights activated. Any objection to that instruction by the defense?
No, Your Honor.
Okay, fleeing to elude a law enforcement officer, any objection to that instruction by the defense?
No.
Okay, Mr. McMaster, just so you know, I'm going to ask you to give me a whole new set of instructions, because these instructions have, like the printer,
Printing came out.
yeah, it came out kind of bad, and so if we could get a better set. Okay, resisting an officer without violence, it has a statute number in there, so if we could take that out. And then, yeah, I see the capitals. Okay, anything else by the defense?
No.
Okay, that looks good. Then principal will take out the numbers and the statutes. Anything else by the defense?
No, Your Honor.
And then voluntary intoxication will take out the number.
That one should be taken out altogether, Judge. That's one we redid totally.
Okay.
Got a very old instruction.
Would
The
it,
one was submitted separately.
okay, would the one that's submitted separately, is that where this would go?
Yes.
Okay, I'll throw this one away. We'll put this one in. I see some,
Parentheses, I would say we delete alcohol or just refer to controlled substance.
I think that's what we did before. Does this defense agree?
Yes.
And don't forget to bold voluntary intoxication.
Yes. I already got that.
And then it says he or she, be he.
Or she, the next sentence was, or she was.
Okay. The more you can take out, the better.
It's right after that instruction, I think the abnormal mental condition instruction should go. Unless it's a title.
Okay, that's where the diminished capacity instruction?
Yes.
And you're going to retype that.
We're going to retype it to put the term knowingly in. Is there a suggested title for the offense?
Because everything else has a title.
I'll see you need to have a title on that, it doesn't have to be something.
What if we just put defendant's capacity instead of diminished capacity? Do you object to the word diminished?
Or mental condition, since that's in the instruction.
Are you going to put mental
Initially.
I don't want it to look special or different from the other instructions.
We don't have a problem with that.
And just say mental condition?
Yeah.
Okay. Okay, just make sure that's bold and on the top, and then put that instruction in.
And Judge, I would suggest after that, the justify the use of the force instruction that we prepared.
We're working our way through that.
Yeah, it looks like we'll have to make some changes. I see some, we got to bold the front, take out the, bold the top title, take out the, I see Brandon Lee Bradley bolded, all caps, Barbara Pill, all caps. Mr. Moore, let me know when you're ready to address this. Applicable law or the person that's bolded?
Actually, the person's not.
Yeah, just applicable law or the. I see Barbara Pill after that too. I see 2 2s. When you go to 1, 2, and 3, the very first pair? Okay. And they've got, I don't see where everything else has those big paragraphs in them. Oh, I guess they do. Okay, you're okay with that.
Font's different on the third page from personal law, people like this, or whatever, the font's different.
Okay.
Make that bigger.
second paragraph, second page, all the hers could come out, it could be only him.
It's unjustifiable use.
In determining whether the defendant was justified, yes. Him, he,
Yeah, I already highlighted those. It's in the second paragraph.
yes. Second to the bottom, I see Barbara Pill. Do I need to define applicable forcible felony or presumption of fear? Can those come out?
I would say they can come out because they're included in the offenses that the court has already defined for the
Okay, now what part are we talking about? Is that in the middle?
Page 2, kind of near the bottom, second half. In the middle, kind of second half. Just trying to go through this.
Could I suggest, because the way it's written, obviously forcible felony, there's any number of ones and that has to make a selection. I would assume based upon the defendant's statement that the selection would be murder, so I think we could put murder in there, not have to define it. Take out the term forcible felony, put murder there.
Well, shoot could be an aggravated battery, it could be an aggravated assault, shoot at. So, there are a number of forcible felonies. Just one, because it's not just generic. So I'd say don't define one. Leave it at forcible felony.
Jury's not going to know if they consider it as well as a forcible felony.
Because everyone in the books one. So you need to define any forcible felony as common sense thing.
Does the state agree, or is the state requesting that a forcible felony be listed?
All right,
If they want, we'll go with it.
yeah, no. Look at the available here.
We'll reject it, and
No, I'm here to look at it.
if I'm objecting, then
I'm not saying you're I think first degree, first degree, second degree were aggravated battery, aggravated assault, shooting into outside dwelling.
I mean, and we're going to have to define every one of those?
They're all forcible felonies. You know, give the jury working definitions. There's some right off the top of my head, flat.
It says that you have to, kind of have to tell us what you want in there. You have to tell, the defense has to tell me what they want.
Let's say you're limited to one.
No, I don't think you're limited to one, but
Okay, then all. Why limited to one? And if we have to, I'm fine with the name of them. But if they, like, they want to have them all defined, then
I don't think that the state has said that. Which,
No, I'm just,
does the state want them all, if we name them all, does the state want them defined?
I would suggest we just include the ones that I named, first degree, second degree, third degree.
Okay, hold on. First degree, second degree, what else?
Third degree,
Okay,
and that's defined in the state code instructions. And ag battery, and assault, and shooting into an occupied. Those. Otherwise, the jury's going to be distracted. The rules are going to distract the instructor.
Okay, I'm still on this. I just want to make sure, because they're going to have to make these changes.
We're just putting in the titles of the crimes that they're claiming as enforceable penalty.
That's what they're suggesting, but are you asking, is the state asking that they be defined? Okay, I heard first degree, second degree, third degree, ag battery, ag assault, shooting into an occupied vehicle.
Yes.
Third degree murder.
Any degree of murder or manslaughter.
Murder, manslaughter, just a degree of manslaughter.
Any degree of murder or manslaughter.
That's fine.
So we can skip the first, second, third, just say murder and manslaughter?
He's saying any degree of murder
Or manslaughter.
or manslaughter. So you're going to say a forcible felony is. And then the rest of it's, are you okay with the rest of it?
Yes, ma'am.
Okay,
Except for where its names are capitalized.
right, and there's one bold thing, we're going to change that. Okay, are you this, is the state with us?
Yes. Yes.
But the other instruction we provided them this afternoon is the firearm instruction, since we do have the potential enhancements that will come back to the lesser. We determine where to put that.
Okay, I have two instructions up here, they appear to be the same, I haven't looked at them that closely, are they the same? I have possession of a firearm with discharge causing death, and I have possession of a firearm.
One is just the basic instruction, the other one I took out a lot of the stuff already.
Okay, so you want me to just look at this one?
Yes.
Okay,
Edited version.
okay, and what does the defense say to this?
Well, I don't know what we're talking about. I got instruction here, the one the court just read, but it's got statutory language in here.
Oh, it still has that, but there's a lot more other stuff that I've already edited.
Does he have this copy? Yeah, give him the, okay, first we got to decide where we want to put this.
Well, my response is it looks okay. That's a firearm.
I see a lot in it that needs some work, so,
The caps will remove. I would suggest we would eliminate the including a starter gun in the third paragraph.
okay, including starter gun,
Delete that, is that all right?
yes. Oh, is the defense agree?
Yes.
And then again, A or B or both is applicable.
Take that out.
Comment.
Okay, where do we put possession of a firearm?
It only applies to count one. It actually would apply to any of, actually, count one or any of its lessers. So I would suggest if you find Miranda Bradley committed first-degree murder or any lesser included offense.
Okay, so you're saying on the top, if you find that Brandon Lee Bradley committed first-degree murder, you're saying, or any,
Lesser included offense of first-degree murder.
okay. Any objection by the defense?
No.
You think it would come after manslaughter? Is that what you're requesting?
Yes, Your Honor.
Any objection by the defense?
No objection.
Look at where manslaughter is.
And I'll have to add that language several times in the course of the instruction about the any lesser included offense.
Okay, so I'll put it after manslaughter and before theft. Okay, the next one I have is defendant's statement.
Okay.
Okay, it needs to be all bolded. Let me go through it real quick.
But I don't think it shouldn't come in at that point yet.
Come in at what point?
If we haven't done reasonable doubt weighing the evidence.
No, I mean, I'm just saying, okay, I'll put that, you want that later.
Right.
Okay, plea of not guilty, reasonable doubt, and burden of proof. Any objection by the defense? Okay? Weighing the evidence,
Okay.
you want everything in there? You want 6, 7, 8, 9, and 10?
Yes.
Okay?
I don't think 10 applies. No reputation evidence.
So we can take out 10? Okay, any other changes to this being requested? Okay? Okay, defendant testifying, we can take that out. Defendant not testifying,
Okay.
okay?
And then, according to the books, defendant's statements should come in.
Come after that. Any objection to that other than the title needs to be bolded?
Okay.
I want to make sure knowingly is in there. The word knowingly is not in there. Do you want that word?
We call it, we'll put that in.
No, I want to make sure, I want to do it according to this instruction because it's in there a couple times.
I'll put this one.
Okay, it's got it up above, was knowingly, voluntarily, and freely made. That's in the second paragraph.
It only says freely and voluntarily in the first, and then I go back to freely and voluntarily at the end. That is the standard instruction. That's the new one.
That is the new one. Huh, that's interesting.
Doesn't make up my mind.
Does that word belongs in there? That makes sense to take it out of the paragraph. Here, rather than standard instruction.
So what is the defense requesting?
Just add words in all three to make them correspond.
Any objection by the state? Before freely adding the word knowingly.
I'll rearrange them so they all three read the same way.
Okay, because I think the way they do it is knowingly, freely, and voluntarily. Oh, now I see it up here. Yeah, wait a second. It's changed around some.
The second paragraph.
Whichever one, yeah, we'll just do it the same way. They
Yeah, we'll do it the same as the second paragraph all the way through. Okay. And the defense is okay with that? Are you okay with that? Okay. Then we go to eyewitness identification. Any, okay. Any objection? Rules for deliberation?
No, okay.
Cautionary instructions?
This girl has got some.
Judge number 5, the second sentence, is the judge's job to determine the proper sentence. If they convict on the first-degree murder, it's
Still your job to determine the proper sentence.
Yeah, but that goes, that kind of goes against, yeah, but
This also applies
But it doesn't reflect the jury's role. That's, I know we discussed this well here, but it really isn't an accurate statement. And for one reason, if it's light, it's not up to the judge. If it's a death sentence, it's still not entirely up to the judge. You get into the whole penalty-based instruction, and then of course, well,
Yeah, but they're not supposed to consider that in the guilt phase.
At this point, they shouldn't be concerned at all with detention centers.
For purposes of the guilt phase. Unless I hear more, I'm going to I'm going to overrule the objection. We'll leave that in. Okay, cautionary instruction. Everyone okay with that?
Yes.
Verdict. I know, it is. I think it's the way the instruction is. Mr. Lanning?
Oh, yeah, I'm taking murder form.
Here's referring to the verdict form. We're good on.
Okay, verdict. Okay, then we'll go to the verdict form.
So in the top part, under the letter C, you have to add column, read verdict.
Okay, any objection by the state?
Third-degree felony murders with them up.
Right. And then the interrogatory,
Okay, so for special interrogatory, we delete check only one?
I should read if you find the defendant guilty. Because those-
Yes, so take out check only one, yes.
Right, but also take out the first-degree murder. If you find the defendant guilty. 'Cause these really,
Don't you take out these little lines right here too?
yeah, before the A, B, and C.
Yes. And they're gonna think they have to check something. Okay, I've got something up above. Under C, there needs to be a period at the end. Under D, there needs to be a period, and under E, there needs to be, at the end of the sentence, needs to be a period. Okay,
But if you find the defendant guilty of any offense, you must get to
okay, it should be instead of first-degree murder, any offense? Yes? Is offense the right word?
Not any offense.
A, B, C, or D. Any offense in this count.
Okay, or, well,
Well, yeah, it's on this one.
Only has to count one.
We didn't carry the interrogatories on to the
right.
Do you want to do A, B, D, or C? Or any offense above?
Judge, Mr. Bradley's name is capitalized in the special interrogatory, but not anywhere else. Eliminate the capitals on those.
Okay.
So it doesn't matter. It's first degree murder.
And Barbara Pill under D.
Yes.
I think after following, don't you think it should have a semicolon?
Yes.
Or a colon? That's a colon, not a semicolon. Colon. Okay, do we want, if you find the defendant guilty, do you want A, B, C, or D, or do you want any offense above?
It's either or. Any offense above is fine.
Okay,
Okay, so this, you find the defendant guilty of any offense above,
comma,
you must answer the following questions.
Question A, we should start with.
okay, did the defendant, Brandon Lee Bradley, actually possess a firearm during the commission of the offense? And if yes,
And that
to,
should come out of
pardon me? And that M, yeah. If yes, I think it's supposed to be a comma. If yes to A, comma, did the defendant, Brandon Lee Bradley, discharge a firearm during the commission of the offense? Yes, no. I think you're right, there's no D. I hear you whisper over there, but,
We're obviously not whispering very.
no, because I can hear you, but I'm up with you. If yes to B, did the defendant, Brandon Lee Bradley, cause death? Okay, just death is right. Cause death as a result of discharging a firearm during the commission of the offense? Was Barbara Pill a law enforcement officer?
Judge, that's, I don't think we use that. The other ones are the firearm.
We have alleged specifically that she was a law enforcement officer in count one, and I think the jury needs to make a determination.
But what is sentencing?
It's an enhancement if there's a
That it's law enforcement.
right, or second, third, or manslaughter, enhancement.
What, the reclassification or?
Actually, reclassification and the improvement.
You know that,
Two different ones.
Right, murder.
I don't mean to be picky, but are these supposed to be question marks at the end of this, or is it supposed to be period?
Question marks.
Okay.
Why not be?
I mean, it just didn't sound right to me, but everybody, I was thinking, why is it all period? Okay. All right, anything else with regard to this verdict form? All right, I'm moving to the next verdict form. Any objection by the defense to the next verdict form?
Okay.
Okay, I didn't see any. And I'm on the third verdict form. I'm on count 3. Let me see if that says count 2. Yep. Oh, on count, on the second verdict form, count 2, we, the jury, find as follows: as to count 2, it's supposed to be a comma after count 2 on the very first sentence. Okay, now we're on count 3. There's supposed to be periods at the end of each one of these. Okay, other than that, any objection? Okay, count 4, periods at the end of A, B, and C.
There is one on C.
Oh, there is on C? Yep.
One long run on the sentence, period.
You just put the period at the end. That works. Okay, any objection to this by the defense? Okay. All right. Single defendant, multiple counts or informations. Any objection?
Okay.
Submitting case to jury. Normally, there's some things at the end of this. Did we fix all that?
No problem.
Okay, at the, where it says A and B, it should say, these exhibits will be sent to the jury room with you when you begin to deliberate. It says, if you wish to see any exhibit, please request that in writing.
But don't we have different positions on different exhibits? Most of them will go back, but I don't think the deputies want the firearm and the live ammo to go together. And I don't know that sending back the DVD of the defendant's interview is something that we would be doing.
It could go back if they wish to. Normally what we say is these exhibits will be sent into the jury room with you when you begin to deliberate, except for exhibits.
Firearm. Just put the firearm and live ammo will not go back together.
Do you want to say the firearm and ammunition?
Will not go back together, then we can send the firearm.
We'll just say no to, just say firearm and ammunition. If you wish to see these exhibits, please request them in writing. And then we can not send them back together.
How about we just accept the live ammo? Right. If they request to see the live ammo, we'll ask them to bring the firearm out, bring the live ammo.
Keep the live ammo out, and the firearm goes back.
So just say these exhibits will be sent into the jury room with you when you begin to deliberate, except for the firearm.
Except for the live ammunition.
Okay. You say live ammunition. With all due respect, I don't know what live means and not live, so does live have to be in it?
Unfired, previously unfired.
I'm like, what does that mean? I don't think people know what live ammunition means.
You're on.
They know.
Can we have, rather not that firearm go back as well? If they want to see it, we'll take it back.
Doesn't it have the safety in it? And don't you have the key?
I do. It's clear as long as there's no live ammo.
They're going to probably want to see the firearm, I would think.
We don't usually let it go back there, that's why.
Well, they have pictures of it too.
Never had it not go back, as long as you don't send the live ammo.
It's just our practice. We've done. But we don't take it back. If they want to see it,
We'll be glad to take it back to them.
how about we do that, except for the firearm and the live ammunition? If you wish to see those exhibits, please request that in writing. There you go.
All right, we'll do that.
Thank you.
Okay, this is probably a good time to talk about, if they want to view the DVD, how we're going to do that.
We don't. Our purpose, they can have it back there.
Well, they have it back there, we're going to send it back there, but they have nothing to play it on. So in the past, when they've requested something to play it on, what we've done is we've taken the machine back, and one of the court deputies plays it for them and does whatever they want him to do, play it, stop it, does whatever, but he stays with them and plays it. He does it. He's not there while they're deliberating, and then he leaves the room with the equipment.
Fine, that's acceptable.
And we've, at one occasion, we sent back a computer.
Is there a reason that they can't?
I guess it's a computer, right? Is that why?
Well, because it's such an, there's so much stuff to it that, you know, one time we did send back just a computer and we left the computer back with them.
Is there Wi-Fi in the building?
Yes.
Is that a computer with Wi-Fi? Does that open a whole Wi-Fi?
Well, we sent the computer back and it was supposedly it was a computer that was cleared. It didn't have much on it, but I mean, with all due respect, they could probably, who knows what they could pick up.
Well, that's what I'm just saying. If you just send the computer back and it's got Wi-Fi capability, and the courthouse is wired with Wi-Fi, and they have access to the internet,
Yes.
I would prefer that not happen.
So that's, I mean, we've just out of abundance of cautions, we've sent someone back there to view it, help them view it. They didn't stay there while they deliberated, they just did whatever they wanted them to do with the video, and then they came out.
And how about the TV that they saw it on in the first place? Can that go back?
Yeah, that could go back.
Yeah.
That's what we've done in the past, we've just wheeled that whole thing, only if they've requested it.
Right.
And then they've sat there and done whatever they want with them, and then they bring the machine back out when they're done.
Right.
Any objection to that process?
No.
Okay. Okay. Okay, anything else with regard to this instruction? Okay, instructions upon discharge of the jury. I give that, but I don't include that in the packet. All right, I'll keep these here.
I will try to get a hold of Amanda Dunn this evening. I can email a copy of it to your JA. I'll email copies to the defense counsel. So.
Well, you know what? I'll probably be here. She doesn't get here till 9. So if you'll just give me a packet at 8:30 in the morning,
I'll do that also.
I could give it to her.
You want us here at what time?
I said 8:30. That's what time I told the jury to be here. All right, court is in recess until 8:30 in the morning. Thank you.